Good evening. Welcome to Illinois Law, put on by the Illinois State Bar Association. My name is Nancy McKenna, and I'll be your moderator tonight. And we have an esteemed panel. To my far right is Rachel Toft. Rachel is a Chicago attorney practicing in the areas of adoption and family law. Rachel is active with the Illinois State Bar Association, serving on the Standing Committee on Sexual Orientation and Gender Identity, currently serving as the committee's vice chair. She has been recognized as a 2010 Rising Star in Family Law by Illinois Super Lawyers. Rachel also volunteers with the Chicago Volunteer Legal Services Foundation on issues related to adoption and divorce, and serves as a volunteer court facilitator for the Cook County Domestic Relations Division. To Rachel's left is Richard Wilson. Richard is a partner in the law firm of Grundon Levitt in Chicago. Richard is the past chair of the ISBA's Standing Committee on Sexual Orientation and Gender Identity. Mr. Wilson has practiced exclusively in the field of family and matrimonial law for over 19 years. His practice has particular concentration in the area of same-sex domestic relations law, where he has long and uniquely distinguished himself with particular emphasis on non-traditional family law and the rights and interests of persons in same-sex relationships, including marriage and its equivalents, dissolution, custody, visitation, access to children, and domestic partnerships. Mr. Wilson also is currently an adjunct professor at IIT Chicago-Kent College of Law, where he teaches in the LLM program on non-traditional families and the law. To Mr. Wilson's left is Jennifer Shaw. Jennifer concentrates her practice in domestic relations, litigation, planning, and mediation. Jennifer is the past chair of both the ISBA's Standing Committee on Sexual Orientation and Gender Identity, as well as the Human Rights Section Council. Jennifer remains active on both committees, as well as the Family Law Section Council. She is an active member of the Madison County Bar Association's Family Law Committee and Pro Bono Council. Welcome, and thank you.
Thank you.
This program tonight is entitled Understanding the New Illinois Civil Union Act, and we're going to start with Richard Wilson. Technically, the law is known as the Illinois Religious Freedom and Civil Union Act, but we're going to call it tonight the Civil Union Act for short. Richard, could you just briefly tell us about the Illinois Civil Union Act?
Sure. The act went into effect June 1st of this year. It was signed by the governor, I believe, on January 31st, and it passed the legislature December 1st. It essentially creates a status or an institution analogous to marriage in all of its rights, benefits, and guarantees, except the word marriage. So essentially, and it's as we'll talk about later, I'm sure, it's not restricted to gender. So persons of the opposite sex as well as the same sex can get a civil union. But the law, the unique thing about the law is that it explicitly equates parties to a civil union with spouses under all of Illinois law. So any matter concerning parties in a marriage or as defined as spouses are treated equally if they have a civil union. And
Rachel, what are the requirements of the Illinois Civil Union Act?
In order to enter into civil union, you need to be at least 18, not previously in a marriage or a civil union, not related closely by marriage or blood. You go to the clerk's office, the county clerk's office in your county, pay your license fee, same as applying for a marriage license, fill out the application. That license becomes valid one day after and is good for 90 days to go ahead and complete that, and a judge or religious official can go ahead and perform your ceremony, and they'll send in the registration back to the county clerk's office.
Are there any other requirements other than the filing? Can you have this performed in a church?
You can have it performed in a church. There is a protection for religious organizations that they do not have to perform civil unions, but many churches and organizations do perform civil unions. Anybody, religious officials can perform them, judges can perform them as well.
So if I wanted to have a civil union, I could go down to the Cook County Courthouse and fill out the paperwork. How long from filling out the application to when you can have your union performed?
You would fill out the application, you go to the county clerk's office, you fill out the application, that license then becomes valid then the next day.
Okay.
So that next day you can go ahead and perform the ceremony, and up to 90 days from that date. So you have 1 day waiting period, and then you have 90 days that it's still open.
Okay. And Richard, you indicated that you had, under the Illinois Civil Union Act, that the term spouse, that's the significant part of the act. What does it mean under this act to be a spouse?
Well, the act defines, it doesn't use the word spouse. It defines a party to a civil union and then formally equates that with a spouse under all of Illinois law.
Okay.
So there are 3 separate sections of the act that says any party to an Illinois civil union shall be entitled to all the rights, benefits, burdens, protections, and obligations that are accorded or afforded to spouses under Illinois law.
Okay.
And then it goes on to say whether that's criminal law, civil law, administrative law, judicial law, it's very broad and very expansive. In fact, the only limitation it does not, the only limitation or the only thing that it does not do is use the word marriage. Essentially, it's a marriage without the word marriage, as far as the way the act is structured.
Okay. So my understanding under the Marital Act in Illinois is that as a spouse, you do not necessarily have to, you have a privilege against testifying in a criminal proceeding or a civil proceeding against your spouse. So this act affords that same protection to a partner under an Illinois civil union, similar to what the traditional spouse, the term spouse under the other Illinois law would mean, correct?
That's right. That's right. By implication or by inclusion through the use of the word. All manner, even things like tenancy by the entireties, which is a form of property ownership, title to property that's only available to married couples. The law says, not explicitly, but by the way it defines spouse and party, that what's available to married couples is also available to parties to a civil union, and so therefore, like the marital privilege against self-incrimination or against testifying, for example, or tenancy by the entireties, or any other benefits that are available to married couples under state law are available to parties to a civil union.
And speaking of benefits, Jennifer, could you just briefly describe the benefits and perhaps the detriments?
Absolutely. And I think it's important to make a distinction between what benefits are available within the state of Illinois and what benefits are available outside of the state of Illinois.
Okay.
So inside of the state of Illinois, if two people enter into a civil union, be they a same-sex couple or an opposite-sex couple, they are afforded all of the privileges and burdens of being married. So that person, that your spouse under a civil union, would inherit from you the same way that a traditional married spouse would inherit. That person would have the right to make medical decisions for you, absent having a power of attorney. In an emergency hospital situation, they would have the right to come into your hospital room to visit you if you were hospitalized. They have the right to make financial decisions for you. And likewise, they have the responsibility for paying for those bills under the Family Responsibility Act. I think what's important to understand, though, is that even though Illinois has passed this act, the federal government has not repealed the Defense of Marriage Act. And as a result, this is good only in Illinois. So once you leave Illinois, you may not have the same protections. And so it's important to think about that when you're entering into a civil union, because you do not have the same federal tax protections that a married couple would have. So say, for example, in my own situation, if my husband wanted to be on my insurance, we could put him on my insurance and that would not be a big issue. However, if we were in a civil union, it is no longer federally recognized, and so that is now taxable income to me. The portion of his health insurance premium is now taxable income for me and is taxed, and so I pay tax on that. Parties to civil unions, when we start to look at benefits like public benefits, access to health insurance through the state, that is by virtue of state law, is my income would be determinative of whether or not he would qualify for financial aid. It would be determinative as to whether or not he would qualify for Medicare or Illinois public assistance. And so there are some drawbacks. And so the thing that I caution all of my clients, and I think that the panel would agree with me, is before you enter into a civil union, it's very important to visit with a family lawyer so that you understand, given your specific financial circumstances, what entering into a civil union will mean, and to visit with a tax professional, be it a lawyer or an accountant, so that you understand the ramifications on your earnings and your income and just what that will mean to you.
Based on what you've said, Jennifer, it appears that there's some disparate treatment between people in a traditional marriage and people that would form a civil union.
Absolutely.
From a tax perspective. What about from an inheritance tax perspective? Are they taxed disparately as well?
Yes and no.
Okay.
And so in the state of Illinois, no. So there would be no inheritance tax in the state of Illinois. So for the state tax return, there would be no inheritance tax. However, because the Defense of Marriage Act still stands federally, there would be potentially a very large taxable event when one partner dies, and that is currently the subject of some pretty substantial litigation in the Northeast.
Now, what about Social Security benefits and pension benefits?
They're not available. Those are federal programs.
Okay.
And so parties to a civil union are not entitled to federal pensions. However, if one party is a state employee or an Illinois municipal employee, those pension benefits are divisible because it's an Illinois program and not a federal program. So if any of the listeners are state police officers or work for the county, those benefits, those pension benefits are divisible, but the Social Security benefits are not at this time.
Or if a listener was a federal employee and had a federal pension, that their partner under the Civil Union Act would not be entitled to that.
Would not.
Yeah. So there still seems to, it's a start, but there still seems as though there's some equal treatment that needs to be moved along.
It's a wonderful step in the right direction, because for a long time in this state, couples who were not able to be married or who chose not to be married had to go through a lot of steps to be protected within the state. It's still important to do those things now because other states are not required to recognize the civil union. And so just because I enter into a civil union, that does not mean if I am in the state of Missouri or I am in the state of Florida that that state will recognize our union, such that if I end up in the hospital, my civil union partner may not be able to make those decisions. So entering into estate planning and making sure that you have your powers of attorney in line are still important.
Thank you, Jennifer. Now, Richard, what do you think, do you have to be an Illinois resident to, you have to be an Illinois resident to have an Illinois civil union, correct?
Correct.
No. I could be a resident of Wisconsin.
Sorry.
I just wanted to be clear about that. I could be a resident of Wisconsin and have a civil union in Illinois.
Right. There's no residency requirement to obtain a marriage or a civil union in Illinois. I mean, you have to be physically present in the state to obtain the license.
Okay.
But to get the license, you don't have to be a resident.
Okay.
And you don't have to prove residency. people traditionally, and this is why the whole debate about why marriage matters or whatever, how it's different is people traditionally when they got married they didn't look to where they were living or where they might be living. A lot of times they met on vacation somewhere and got married there, or they took the Niagara Sleeper from Penn Station to the Canadian side of the falls because the hotels were there, the view was there, it was prettier, and nobody thought, oh gee, this is Canada, is this a good marriage? Can I take this back to the States? It's the same issue here. We don't require people to be a resident. We just, like all states, we have a residency requirement to get divorced, but not to get married. So the same thing is true for a civil union. And in fact, the law specifically says that it will recognize a same-sex marriage, civil union, or substantially similar legal relationship entered into, legally or lawfully entered into in another jurisdiction. So for all those couples that in the intervening 10 years went to Canada or went to the Netherlands or went to Massachusetts or went somewhere and got married, or got a Vermont civil union, or got a domestic partnership in California, so long as it meets the test of substantial similarity under Illinois law, which is fairly broad, their relationship is now recognized in Illinois. So they may have been living here for years, no longer together, and now they're treated as a married couple, and they have a different status than they had before June 1st, or better still, for those who have broken up, they now can get divorced because the law will recognize them fully as though they had obtained the civil union in Illinois or technically gotten married for all purposes, whether it's intact because they're together or they're splitting up. So it gives broad recognition to relationships entered into in other jurisdictions.
So in a dissolution, do you think it's as protective as people covered under the Marital Act?
Yeah, I think one of the greatest, I've often said one of the greatest benefits of marriage is divorce, because it gives people equity and a forum and a right to resolve their differences as equals, which was denied to people who didn't have relationship recognition. So to the extent that, yeah, dissolution or divorce is strictly state law. It's not federal law at all, except the tax end of it. It's all governed by state law. So under the Act, divorcing or dissolving unions or partnerships or marriages are treated the same as marriages under the Illinois Marriage and Dissolution of Marriage Act, entitled to all the same benefits and burdens and protections, the rights to equitable division of the property, spousal support, or what we used to call alimony, child support, or if there are children, equitable distribution of their debts and other, they're entitled to the entire benefit of the Act. They have problems with DOMA, the Defense of Marriage Act, as Jennifer said, because federal law will not recognize anything that is not federally determined to be a traditional marriage, and because most tax law is federal law, then there could be a problem. But otherwise, with respect to the whole process of divorce, it's virtually indistinguishable.
Let's use the example of a federal pension again, and there's a dissolution of a civil union. There's nothing that prohibits the private parties from entering into their civil union dissolution. Do they have a settlement agreement like a marital dissolution? Sure. And voluntarily saying that, can they voluntarily say that someone will get a percentage of their pension?
Sure.
They can.
But the federal government has no obligation to honor that agreement.
Oh, so
and the
not
problem
really.
with that is, which as Jennifer said, I mean, we really need to underscore that people need to get good advice, because especially with taxes, in a traditional divorce, the division of the marital property is not taxable. Well, that's a federal tax regulation. That regulation is not available to the divorcing parties to a civil union. So their estate's going to be treated differently, and they're going to have tax issues. The same with, for example, a federal pension, because a pension is not worth the same as the house, for example, because it's deferred tax money in a pension that won't be taxable till the parties start drawing down on it. So it's generally divided differently in a divorce than current taxed dollars. And so issuing what's called a qualified domestic relations order to a pension plan that's governed by federal law, the plan can just ignore it if they want to. There's no obligation that they have to enforce it or honor it, I should say.
And piggybacking onto that, it has not always been the case for dissolution of heterosexual marriages that divorce was a non-taxable event.
Right.
And so what I see happening, and again, another reason to get really good advice, is that there were mechanisms for making sure that divorced parties, divorced spouses could obtain a portion of the pension. And I think what we're going to see is, at least for now, until this is sorted out on a federal level, going back almost 20 or 30 years to the way we used to do things for parties who are dissolving a civil union. But I think one of the biggest, although you may be able to divide that pension, one of the biggest problems is you will not be treated as a surviving spouse. So when the party who receives the pension dies, the pension will die along with that person.
That's an extreme disadvantage. Just an extreme disadvantage for
Yes.
people that are in long-term civil unions, because people who are in long-term marriages do not have that same impediment.
Exactly.
Or even Social Security, for example.
Right.
I mean,
There's no retirement
long-term
assets.
marriages where one party didn't work. I mean, they
Right.
depend on that survivor benefit from Social Security. It's not available. Or another thing that's governed only by federal law is immigration. The right to sponsor a spouse from a foreign country is absolute under American law. You marry someone from a foreign country and you have an absolute right, subject to certain qualifications, if it's determined to be a sham marriage, which is
Right.
unusual,
Right.
but it happens. But other than that, you have an absolute right to sponsor your spouse and bring your spouse to the United States as to become an American citizen. Well, immigration law is strictly federal law, except what's going on in Alabama and Arizona. But and that benefit won't be available under DOMA, under the Federal Defense of Marriage Act. That ability, that benefit, that federal benefit is not available to parties to a civil union because the spouse is not recognized.
Well, thank you, Richard. Thank you, Jennifer, and thank you, Rachel. I wanted to just ask you, when we wrap up, we've got about 5 minutes left here. I wanted to just ask you, what do you think the best thing that's come out of this act? What's the strongest benefit from the Illinois Civil Union Act? If you each could give me your opinion, what do you think is the best thing?
The recognition of the relationship, recognition of your
Okay.
status in your relationship. If you're in a committed relationship, you should be entitled to have that status, you know, irregardless of looking at all the tax benefits and all the money issues. To be able to have that recognition of your relationship is really important.
And it allows you to adopt children.
Mm-hmm.
It allows you to do things without that recognition of that relationship that you wouldn't be able to do otherwise. What do you think, Richard, do you have any difference? And what do you
I
think
was
is
going
the
to say the same thing. I think the recognition, the equal treatment, the fact that the state is saying that we, short of using the word marriage, which is a political determination, political question that's not, we're not discussing here.
Right.
Short of that, if we just take that off the table, the state's essentially saying we're going to treat you equally for all respects under state law, which is an enormous step forward as far as equality is concerned, and as far as the state's promise of equality is concerned to its citizens. And it's saying that, you know, it doesn't matter, we're giving you the opportunity. And because, and I can't underscore this enough, because this culture, the American culture, so honors marriage, not strictly in a formal sense, but in a political sense, in terms of all the benefits and obligations that it bestows upon married couples that it doesn't give to anyone else. It's critically important because that's where everything is available to parties. And parties who are not in formally recognized relationships have virtually no legal protection. So it's an enormous step forward in terms of equality.
Thank you. And Jennifer, what do you think is the strongest or best thing that's come out of this act?
I agree completely with Richard and with Rachel, and I think just the concrete examples of being able to, with one solemnization, going to the courthouse, going to the officiant, you now have the ability to do all of the things that other couples who were able to legally marry can do without interference from family members, without interference from anyone else. You can stand up and say, this is the person who I choose to be my partner, and this is the person who I choose to make these decisions for me. Because previously, there were battles, and we've all heard about them in the news, where long-term couples were together and there was a disapproving family member, and when one party would fall ill, the long-term partner was cut out of end-of-life decisions. And that's not the case anymore.
What do you think the shortcomings, the strongest shortcoming of the Illinois Civil Union Act is? Rachel?
Well, a lot of what we discussed with the disparate treatment with the federal benefits too. I mean, when you're in the state of Illinois, you're afforded all the rights and responsibilities of a married person. When you leave its borders, you may or may not be recognized, you know, state to state. DOMA allows other states to essentially ignore your status. So just the different treatment between once you leave the state of Illinois.
Okay. Richard?
I would probably agree, other than to also say the fact that it's simply not marriage. Everyone knows what marriage is. Civil unions, domestic partnerships, they're created by state governments, political trade-offs, political decisions. Marriage laws are not formal and elaborate. It's the divorce laws that are. A civil union law is formal and elaborate because it's trying to be equal. So if it were just marriage, it would...
Thank you so much. Thank you, all of you. It really was very informative. Thank you.
Thank you.
Good night.